from supplemental is orders item 3, 1st April 367 of 2018, along with item 4 to 401.
Office note minded, I have gone through their several interlocutory application which have different.
जो आइए फाइल वास को अलग से कितने सब्स्टिट्यूशन फाइल में
21.
हाँ
21.
21 cases आपको कोई इंस्ट्रक्शन तो नहीं आया होगा अभी तक नो इंस्ट्रक्शंस The Learned Counsel for the applicant in FA number 367 of 2018 submits that कौन से ऑर्डर में हुआ था
Fifth August, 25th July.
First August 2000 देखिए The Learned Counsel for the applicant in FA number 367 of 2018 has submitted that pursuant to order dated 18/7/2025, he has received no instructions with regard to out of court settlement of the proposal of the claimants. At this, the Learned Counsel for the respondents, the Learned Counsel for the claimants has submitted that the case has to be decided on merits. हो गया कहानी खत्म इसका. उसके बाद आइए किसके कौन सा आइए हैं ये सारे आइए हैं
293. Item 105, 1st April 293 of 2014.
objection? IA number 10691 of 2025, in first appeal number 293 of 2014. The learned counsel for the appellants representing the claimants has submitted that the interlocutory application has been filed for substitution of the legal years of deceased appellant number 1, 2 and 4 after setting aside abatement and for condonation of delay, if any, in filing the interlocutory application. The learned counsel submits that the details of that appellant number 1 died on 1/2/2018, appellant number 2 died on 10/12/2022, and appellant number 4 died on 18/12/2015. The learned counsel submits that there has been delay in filing the interlocutory application, but the Union of India as well as the claimants are aggrieved by the same award, and ultimately the claim, and he has also submitted that the entitlement and quantification of the claim is yet to be crystallized. He submits that considering this aspect of the matter, the interlocutory application will be allowed so that the appeal is ultimately decided on merits. He has submitted that there are other appellants also on record.
And still some I filed several all.
नहीं जानते, ये सब कहानी इंस्टॉलमेंट में चलते रहेगा ना.
They are in pipeline.
किसी दिन किसी का जो है ना अबेटमेंट होगा. अब जो आपका ये पाइपलाइन वाला जो है ना बात, ये आपका वर्बल नहीं चल सकता है.
Yeah, already I filed, but the number is not.
कहाँ फाइल?
लेकिन डिफेक्टिव है, इसलिए उसे प्रीमियम
डिफेक्टिव है, फाइलिंग ही डिफेक्टिव.
Effective actually in the cost title manner, in the index page manner, the name is not telling. That's why it's.
The learned counsel for the appellant and the learned counsel for the respondent Union of India has no serious objection so far as the substitution, setting aside abatement and condonation of delay is concerned. The wakalatnama on behalf of the proposed legal heirs and successors has already been filed along with the interlocutory application. After hearing the counsel for the parties and considering the aforesaid facts and circumstances, the fact that the award is under challenge by both the parties in this batch of cases, and the matter relates to compensation arising out of land acquisition. The IA number 10691 of 2025, seeking substitution, setting aside abatement and condonation of delay in filing the petition for substitution is hereby allowed. The learned counsel for the appellant is directed to delete the name of the appellant number 1, 2 and 4 from the cause title and insert the name of the legal heirs and successors. In red ink during the course of the day. फर्स्ट पेज में नहीं हटे तो पीछे कर देंगे. चलिए बाकी सब सेम कहानी.
Same.
सब में पैरा 2.
Paragraph 2 every.
आप पिछली बार उसका सॉफ्ट कॉपी नहीं दिए थे ना. गलत है ना.
नहीं, I have given the.
नो, बाद में हमारा ऑर्डर अपलोड होने के बाद आपका आया है.
After 2 days I provided that.
ऑर्डर अपलोड के बाद.
और आपको भी कुछ सब्स्टिट्यूशन इसमें फाइल करना है.
इसी का मतलब
कब करना है?
मतलब
उसका तो आपको होश ही नहीं.
नहीं,
अब
नहीं,
तो आ गया रिकॉर्ड पर.
मेरा तैयार है हुजूर. इसमें हो रहा है कि आज फिर कुछ आइए बच गया है, तो मतलब इंस्टेड ऑफ फाइलिंग 3 or 4 substitution petition, one my lord I have prepared the format.
आपके यूनियन ऑफ इंडिया को पैसे की कमी हो गई है तो 4 फाइल कर दीजिए अपना जितना है उतना कर दीजिए फिर और कर दीजिए
My submission is keep a file कर दीजिए but
इनका तो कोई
notices
इतना
are not required. I will file वकालतनामा on behalf of all.
कहाँ आप तो कुछ कर ही नहीं रहे हैं
They are in process my lord. हम फाइल कर देंगे. Notices are not required in this case. हम सब ला के दे देंगे. ये सब जमा हो रहा है गांव के लोग जमा कर दे रहे हैं.
These 4 days are dedicated for this case only, my lord, 14 to 17.
14 to 17 is meant for this
For
चलिए
this.
आज़ादी दिलाइए लोगों को अपने चंगुल से
और हम अंडरटेकिंग ले रहे हैं क्या?
ठीक सब अलाउड है ठीक है पंकज जी आपको देखना है प्रेयर सबका सेम है पैरा 2 में ही लिखा हुआ है सबका कौन कौन अपीलान मरे हैं और कब डेथ हुआ उसमें लिखा है सबका तो उसका सेम ऑर्डर है ठीक है ऑल 21 केसेस का आइए वी आर अलाउइंग एक चीज और इसमें रहेगा इट इज मेड क्लियर दैट दिस सब्स्टिट्यूशन इज ओनली फॉर द पर्पसेस ऑफ द प्रेजेंट अपील एंड नॉट फॉर एनी अदर पर्पस पिछला ऑर्डर में ना हम लोगों ने ऑर्डर ड्रॉ किया था कई सारे सब्स्टिट्यूशन का आई थिंक मुकुल जी ने किया तो उसी हिसाब से इसमें करते हैं अब बताइए बाकी सबका क्या करें इंस्टीट्यूट कब तक हो जाएगा आपका
Institute about the
तो रिमेनिंग जो डिफेक्टिव आपका आई है
हमको 22 तारीख तक का डेट दिया है 22 is Thursday Friday prior to Friday I will file
तो अभी तक आपका डिफेक्ट में है तो आपको डिफेक्ट
डिफेक्ट वाला तो कर एक पेज चेंज करेंगे दैट विल बी क्लियर उसमें 60 वी आर फाइल आई है तो उसमें 60
अभी और 60 बाकी है
60 में से 21 निकला अभी और 40 के करीब और अभी और आ रहा है
The Council for the Claimants has submitted that in other cases also interlocutory applications has been filed seeking substitution which are yet to be instituted. At his request, the matter is directed to be posted on 21st. ठीक है उस दिन सादे करेंगे अब उससे पहले कर लीजिए on 21st of August 2025. हाँ आइए इनका पास ओवर जो मैटर है जो चल रहा था वो इसी का लिखना है
Pursuant to item 2 from daily list, second appeal 97 of 2004.
Did you get some judgment?
We had put following several people these things.
You are the purchaser and there are two appellants. There are two appellants before this court. Who is the second one? The vendor. Your vendor is also the appellant.
No, I am the only applicant.
You are the only appellant.
The rest of the purchaser.
No, there are two appellants. One is Chandrika Singh and his wife.
Why?
It was sold jointly in your name.
No, purchase in exclusive name.
Then why Gauri Devi, his wife, has come?
Wife is also one of the purchaser and is joined in the written statement with the different number 2.
The wife of Chandrika Singh.
Yes.
Husband and wife have come before this court.
Yes.
Yes.
Because she is also one of the co-sharers.
She is one of the co-sharers.
Co-sharer.
And she has sold to whom?
She has not sold. Munisar's daughter is one of the brother's daughter. She has sold it to Chandika Singh, the husband of Gauri Devi.
Why Gauri Devi became the party? Because she is one of the co-sharers. She is defendant number 3 and 4.
Joined as a husband-wife. That's why they are two sisters.
These appellants are related to the vendors or the family,
All related to the family.
including the purchaser.
Purchaser.
Purchaser is also related to the vendors.
Yes, husband of the defendant number 5.
Okay, defendant number 5 is a co-sharer.
One of the co-sharer.
And she sold to her husband.
No, she not.
No, one another co-sharer.
Brother's daughter.
Yes, brother's daughter.
Only brother. Her daughter sold it to you. Was not in dispute the issue of 5 is a co-owner in respect of 50% share of the property in terms of the dictum of the Apex Court so and so. Respondent number 4 is not precluded from transferring her interest in the joint property prior to the partition.
Para number 13. Read para 14. ये जजमेंट का para 14. Ready? 14.
Section 44 of Transfer of Property Act provides for the right of the owner to transfer his share in the joint property. In doing so, Section 44 provides that where one or more of the owners of an individual property transfer their share or any interest in such property, the transferee acquires in respect of such share or interest, and as far as necessary, the transferor's right to joint possession or other common or part enjoyment of the property. It is however pertinent to note that while section 44 of the TPA provides that a person cannot transfer a right greater than he himself has reference so and so, the same does not preclude the owner from transferring his share in the joint property only for the reason that same is unpartitioned and undivided. In respect of Supreme Court in Kartar Singh's case, as regards the difficulty pointed out by the High Court, namely the degree of passive performance cannot be granted since the property will have to be partitioned. We are of the view that this is not a legal difficulty. Whenever a share in the property is sold, the vendee has a right to apply for partition of the property and get the share demarcated. We also do not see any difficulty in granting specific performance merely because the properties are scattered at different places. There is no law that property to be sold must be situated at one place. As regards the apportionment of consideration, since admittedly the appellant and respondent's sister each have half share in the properties, the consideration can easily be reduced to 50%, which is what the first appellate court has rightly done. Additionally, in the case of Nasib Kaur and other, the Honorable Apex Court observed that the unpartitioned share in joint property can be sold by the joint holders prior to partition. It was, however, noted that the interest so acquired by the transferee would be the same as that held by the transferor, and that same would be subject to final determination in partition proceedings. In the present case, as well as petitioner is essentially agreed by that the suit for specific performance therefore the respondent one was decreed in favor of respondent number one in terms of the compromise between
Yes,
the
respondent. Undivided portion of the suit property can be sold by a co-owner of the property under joint family. If there is a purchaser of undivided portion, then his sale deed, how does it become null and void? It cannot become null and void.
the what will not the share is below the loss will be there.
That's right. The share is not clear, right? Then the person who is purchasing the property has got the right to partition, to seek partition, and the person who is suppose there are other co-partners and somebody has sold the property, maybe in excess, right? Then also he can seek partition, and then whatever be the sale will be subject to whatever is ultimately decided in the partition suit. Whosoever is the vendor in relation to the sale deed, her share will be all marked, and only that portion will ultimately get transferred. Therefore, the co-owner of the property or co-partner in the joint family or a joint owner of the property has a right to seek partition. This is what the question of law is. This does not make the sale deed null and void. भाई दो भाई हैं, joint family property.
But he cannot sold the entire property and more than this.
So therefore you seek partition. And then ultimately what will happen? Whatever share will come to the vendor, he cannot transfer better title than what he has. If he has only half share, he will get only half share. And he will not seek partition, you know why? Because he has got a registered sale deed which is more than the share of the vendor. तो वो क्यों जाएंगे अपना partition कराने के लिए? तो कभी नहीं जाएंगे. Therefore, you should have gone for partition. If you go for partition, then whatever has been sold will come to light, and he will get share only to that extent. समझ आ रही बात? ऐसा आपका right खत्म नहीं हो रहा. But you should know what relief you can seek. देखिए, that should be sufficient. And एक और चीज़ है, you see, a portion of the property पर कोई बेच दिया. Whenever there is a partition, there could be numerous properties apart from this. Initially, a partition was claimed that there was already a previous partition. That has been rejected. Previous partition का कहानी खत्म हो गया. There could be a possibility that the family has more properties. Then whatever has been sold can be adjusted accordingly.
But that has not.
That has not come. We are just discussing that what is the relief in a case where a co-partner of the family sells undivided share of the property, that itself will not make the sale deed null and void.
But my lord, he is entitled only for the.
Certainly, that we will observe. That will be dependent upon the decision of the partition suit that you will file.
That
Right.
will be.
Second appeal number 97 of 2004. Heard the learned counsel appearing on behalf of the parties. This second appeal has been filed against the judgment and decree dated 19 February 2004, within bracket, decree signed on 28/2/2004, passed in title appeal number 23 of 1995 by learned additional district and sessions judge, fast track court number 1, Gumla, reversing the judgment dated 22nd February 1995, within bracket, decree signed on 6/3/1995, bracket close, passed by the learned sub-judge Roman 3 Gumla in title suit number 41 of 1990. The
the C has also executed one another sale deed.
That is a subsequent sale deed.
Subsequent sale.
उसको तो challenge नहीं किया
Challenge, but my lord, so far as the share is concerned, my lord, that may be included.
I will.
That I will
We do not know. We will only say that undivided portion was sold, and extent of since there has been no partition, we do not know as to who would, to what extent they will get it.
Sold, my lord, the 17 decimal and the 5 decimal.
17 and 5. 5 is subsequent.
Subsequent.
So
22
we are
decimal.
not concerned with the subsequent sale deed.
But my lord, that may be observed.
That is the subsequent sale deed.
No, that is not the subject matter of the suit.
That is not the subject matter, and moreover, it is not the. It is subsequent sale deed.
Subsequent sale.
That is not the subject matter of the suit.
But
The claim of the appellant would ultimately depend upon partition of the property. That should be sufficient. This appeal has been admitted for final hearing by the order dated 18/5/2006 on the following substantial questions of law. By addressing the first substantial question of law, the learned counsel for the appellant has आपका लिखते fairly submitted that he had the locus. उस पे भी आपको objection. First substantial question of law.
but that does not appears to be correct.
Okay.
This is a factual locus standard because plaintiff is one of the co-sharer.
Yes.
So
The
any property is sold, he may be affected. So it may be a person agree. So might have a locus standard.
the learned counsel for the the learned counsel for the respondent has submitted that the plaintiff was the co-sharer of the suit property and the previous partition with respect to the joint family property was not proved, and therefore it cannot be said that the plaintiff did not have the locus to file the suit. The learned counsel for the appellant has submitted does not dispute this fact that the plaintiff was the co-sharer of the suit property as per the findings recorded by the learned courts, and he submits that the first substantial question of law, he has submitted that under such circumstances, he has fairly submitted that under such circumstances, it cannot be said that the plaintiff did not have the locus standi to file the suit, as a portion of the entire property was sold by the defendant number 1, the co-sharer. In view of the aforesaid submissions, this court is of the considered view. This court has also gone through the impugned judgments and is of the considered view that the plaintiff claiming to be the co-sharer of the property had the locus standi to file the suit. With respect to the second substantial question of law, the learned counsel for the appellant has submitted that the property admittedly belonged to the common ancestor, namely Gokul Kumbhar, and the subject matter of the suit was challenge to sale deed dated 29/6/1990, executed by one of the co-sharers of the property. The learned counsel has also submitted that the appellant number 1 herein is the purchaser of the property, and appellant number 2 is the wife of appellant number 1 and was defendant number 5 of the in the suit, and was also a co-owner of the suit property. The learned counsel submits that the defendant number 1 was also the co-owner of the suit property, and in view of section 44 of Transfer of Property Act, the sale by the defendant number 1 in favor of the defendant number 2 cannot be said to be void ab initio. Rather, the purchaser of the suit property has a right to seek partition and get his share earmarked, share of the vendor earmarked, and even the plaintiff who had challenged the sale deed dated 29/6/1990 could also claim partition. And if there was any excess, any portion sold in excess of the share of the vendor of the defendant number 2, then under such circumstances, in the suit for partition, this aspect of the matter can also be taken care of. He has submitted that the learned first appellate court has, while reversing the judgment, has declared the sale deed number 1817 dated 29/6/1990 as null and void. Such finding is contrary to law and in disregard to the provision of section 44 of Transfer of Property Act. The learned counsel for the respondents has, while opposing the prayer, has submitted that 2 sale deeds were executed by the defendant number 1 in favor of the defendant number 2. One was sale deed number 1817 of 1990 dated 29/6/1990, whereby .17 acres was sold out of total area of 0.34 acres, and other was exhibit number A by 1, whereby further 0.05 acres was sold to one Barik Abhay Kumar Singh on 13/8/1990, and thus the defendant number 1 sold 0.22 acres out of suit land, although as per the finding recorded by the learned First Appellate Court, she could have sold, the defendant number 1 could have sold her share only to the extent of 0.09 acres. Correct?
Total area is 0.28.
0.2834.
28. Highest distance.
अच्छा, जहाँ पे 34 है ना, वहाँ पे लिखिएगा 0.28 acres. The learned counsel has submitted that a vendor cannot, a vendor, even if co-owner of the property, cannot transfer more than his share. And therefore the sale deed was illegal and not
One
sustainable.
more submission. So far as the Gayatri Devi is concerned, he herself admitted that she has not executed any sale. She is illiterate lady, and
He has also submitted that the vendor, it was a specific case of the vendor, Gayatri Devi, that is defendant number 1, that she had not executed the sale deed and the sale deed was forged and fabricated, and she is an illiterate lady. In response, the learned counsel for the appellant has submitted that in absence of any partition suit, the actual share of one or the other co-sharer cannot be earmarked. The learned counsel has submitted that since the suit was not seeking partition of the property and the claim for previous partition was disbelieved by the court, therefore the illegality and validity of the sale deed and the extent to which the purchaser would get the property by virtue of the sale deed can be decided only when there is partition by meets and bounds. Correct? After hearing the learned counsels appearing on behalf of the parties, this court finds that title suit number 41 of 1990 was filed by Ramesh Kumhar seeking declaration that the sale deed bearing number 1817 dated 29/6/1990 executed by defendant number 1 Gayatri Devi was illegal and void document, on the basis of which the defendant number 2 could not acquire any title over the suit land. The specific case of the plaintiff was that the land that suit land comprising of khata number 25, plot number 352/353, total area 28 decimal, was ultimately purchased by one Gokul Kumhar in the year 1925. And Gokul Kumhar had two sons, Bhaglu Kumhar and W. Kumhar. And Bhaglu Kumar died leaving behind 5 daughters and 1 son, namely Sukhni Devi. Namely Sukhni Devi, Sukro Devi, Pairva Devi, who were all dead, and Gauri Devi and Mangri Devi, and a son, Muneshwar Mehto, of the defendant number 1 was the only heir and the daughter of Muneshwar Mehto, namely Gauri Devi and Mangi Devi, were made defendant number 5 and 6 in the suit. Sorry?
This Gauri Devi and
Huh.
they are daughter of Bhavlu. Gayatri is the daughter of Muneshwar, one daughter.
ये गलत लिखा है क्या इसमें? Just a moment. इसको जहाँ से लिखे हैं ना, कॉमन एंसेस्टर का नाम गोकुल कुमार, राइट?
He has two sons, Bhavlu and
Just a
Bhavlu.
moment.
Bhavlu has five.
Just a moment. The sage Gokul Kumar had two sons, namely appellate court के जाके से लेंगे, namely Bhaktu Kumar and W Kumar. Bhaktu Kumar semicolon डालेंगे. Bhaktu Kumar had 5 daughters and 1 son. Out of the 5 daughters, 3 daughters had died, issueless. However, Gauri Devi and Magni Devi were alive. It was the case of the plaintiff that Gauri Devi was living with defendant number 2, Chandrika Singh. Full stop. Bhaktu Kumar had 1 daughter, namely Gayatri Kumar. Muneshwar Mehto.
Only daughter.
Muneshwar Mehto, Bhaktu Kumar had a son, namely Muneshwar Mehto, who had 1 daughter, namely Gayatri Kumari, defendant number 1. W. Kumar had 2 sons, Rameshwar Mehto, plaintiff, and Bhuvneshwar Mehto. Bhuvneshwar Mehto died leaving behind Lal Keshwar Mehto and Vishwanath Mehto, within bracket defendant number 3 and 4 respectively, and Gauri Devi and Magni Devi were defendant number 5 and 6 respectively. It was the further case that the property was in joint possession as per the further case of the plaintiff. The defendant number 1 executed a deed of sale in favor of defendant number 2 with respect to the suit land at the instigation of defendant number 2 for rupees 3,000 as sale deed number 1817 dated 29/6/1990, which was not enforceable and binding upon the plaintiff. It was asserted that neither the defendant number 1 nor the defendant number 2 had any right, title, interest and possession over the suit land. And it was asserted that the suit land was, the sale deed was null and void. Defendant number 2, 5 and 6 file written statement opposing the suit. And inter alia raising a plea that the suit property was not in jointness, rather there has been a previous partition. And a memorandum of partition was also prepared in the year 1956. And the suit property belonged to the father of defendant number 5 and 6, Bhulu Kumar, who died sometimes in the year 1957. And the suit property was inherited by his daughter and son, Muneshwar Mehta. It was therefore the case that male issue of Muneshwar Mehta died and his daughter Gayatri Devi inherited the suit property, being the rightful owner. It was therefore the case that the defendant number 2 defendant number 1 was the owner of the property and had rightly sold the property through registered deed to defendant number 2, in which he has constructed a house and was residing with his family. It was also the case that full consideration amount was duly paid. So far as the defendant number 1 is concerned, defendant number 1 also filed a separate written statement.
Yes. We supported the plaintiff.
So far as defendant number 1 is concerned, she supported the plaintiff and alleged that the sale deed was executed fraudulently. The trial court framed the following issues for consideration. Issue number 4, इसको quote करना है. The issue number 4 was relating to previous partition, and the issue number 5 was relating to legality and validity of the sale deed number 1817829/6/1990. The learned trial court, after considering the materials on record, held that the defendant number 2 and 5 and 6, who had come up with a plea of previous partition between Bhaglu Kumar and W. Kumar in the year 1956, and had produced Exhibit C, being the deed of partition dated 25/2/1976, was held to be not a reliable document. The learned trial court ultimately held in paragraph 10 of the impugn judgment that the defendant number 2 and 5 and 6 have succeeded in proving partition However, the learned trial court, after considering further materials on record, held in paragraph 10 that the defendant number 2 and 5 and 6 have succeeded in proving partition. So far as the case of defendant number 1, that the defendant number 2 had fraudulently got the sale deed executed from her, the same was rejected, and by considering the materials, and ultimately it was held that the defendant number 1 has failed to prove that the sale deed dated 19/6/1990 is a result of fraud. The learned trial court ultimately held that the learned trial court ultimately held that the sale deed was legal and valid document and binding upon the defendant number 1, and accordingly both the issue number 4 and 5 were decided in favor of defendant number 2, 5 and 6. So far as the learned first appellate court is concerned, it framed the following points for determination at paragraph 6, which are as under. The learned first appellate court considered both the points for determination together. Ultimately held that the defendants failed to prove partition in the family of the common ancestor Gokul Kumar. The finding of the learned trial court with regard to previous partition was reversed by the learned first appellate court, and the finding of the first appellate court has become final as no substantial question of law has been framed in that regard. However, the learned first appellate court further proceeded to decide the legality and validity of the sale deed number 1817 of 1990, dated 29/6/1990, and observed that .17 acres towards the east of the property was sold by this sale deed, and further observed that even if the partition deed is presumed to be genuine, then there was only 0.28 acres of sweetland, and Magni Devi, Gayatri Devi and Gauri Devi were the legal heirs of Guglu Kumar. So Gayatri Devi had only 0.09 acres of land, The learned court also recorded that neither Magni Devi nor Gauri Devi were examined, and further observed that from perusal of Exhibit A by 1, 0.05 acres of land out of 34 acres in plot number 353 was sold by Gayatri Devi to one Barik Abhay Kumar Singh on 13/8/1990, just after 2 months after the deed executed by Gayatri Devi in favor of Chandrika Singh, the defendant number 2. The learned court also observed that by virtue of Exhibit A and A by 1, it appeared that Gayatri Devi sold 0.22 acres, but in the suit land, she had only 0.90 acres. The learned first appellate court observed that the Sada Batwara deed exhibit C was prepared during the pendency of the suit only with ulterior motive of Chandrika Singh, defendant number 2, to grab the property of Gokul Kumar. And ultimately declared the sale deed number 1817 dated 29/6/1990 as null and void. And since the deed was only for 0.17 acres, the suit was not hit by the non-joinder of Barik Abhay Kumar Singh as necessary party. The first appellate court ultimately held that there was no partition between Guglu and Guglu Kumar, and the family of Gokul Kumar was joined, and Gayatri Devi had no right to execute the sale deed regarding the suit land without the consent of other co-sharers in anyone's favor, and consequently held that the deed number 1817 dated 29/6/1990 was null and void, and the defendant number 2, Chandrika Singh, had no right to enjoy the suit property as his own. And the learned first appellate court ultimately set aside the judgment and decree of the learned trial court. This court finds that the learned first appellate court declared the sale deed number 1817 dated 29/6/1990 as null and void on the ground that the property of Gokul Kumar was joint and Gayatri Devi was only one of the co-sharer of the property, and she could not have sold the property without the consent of the other co-sharers in favor of one or other person. The plea regarding previous partition and the plea regarding fraudulent execution of sale deed was rejected by the learned first appellate court. In this background, the second substantial question of law is to be seen in the light of Section 44 of the Transfer of Property Act. In view of the findings recorded by the learned first appellate court, there can be no doubt that the vendor of that Gayatri Devi, the defendant number 1, the vendor was a co-sharer of the property, and the plaintiff challenged the sale deed dated 29/6/1990 but did not make any prayer for partition of the suit property, although claimed that it was the property belonging to Gokul Kumhar, the common ancestor. Admittedly, the defendant number 2, purchaser of undivided portion of the suit property belonging to the common ancestor Gokul Kumhar, never filed any suit seeking partition and for recovery of possession. And it appears that,
He is already in possession.
and it appears from the record that the defendant number 2 was already in possession of the suit property. This court is of the considered view that once a co-owner of the property belonging to common ancestor executes a sale deed, the sale deed by itself does not become null and void. The share of the sale deed would certainly be valid to the extent the vendor, being the co-owner, had the share in the property. This court is also of the view that in absence of any prayer for partition and in absence of any suit seeking partition, the exact share of one or the other co-partner or co-owner of the property cannot be ascertained. In such circumstances, the plaintiff who had challenged the sale deed on the ground that it was a joint family property and the defendant number, in such circumstances, the sale deed executed by defendant number 1 in favor of defendant number 2 will certainly be subject to any partition suit or partition amongst the descendants of the common ancestor, namely Gokul Kumhar. And the sale deed could not have been declared to be null and void by the learned First Appellate Court, merely on the ground that the property was the undivided share of the property, merely on the ground that the property being joined, the defendant number 1 had no right to execute the sale deed regarding the suit land without the consent of the other co-owners. The second substantial question of law is accordingly answered by holding that the suit for declaration of sale deed dated 29/6/1990 as illegal was not maintainable in absence of a prayer for partition of the joint estate of common ancestor of Gokul Kumar. रिकवरी का भी प्रेयर होना था
recovery of the excess amount जो है excess
and seeking recovery of possession of the excess property,
during the sale.
if any, depending upon the share to be earmarked with respect to one or the other co-sharer of the property through partition and recovery of the from Chandrika Singh, defendant number 2. The second substantial question of law is accordingly answered in favor of the appellant, and consequently the finding of the learned first appellate court that sale deed dated 29/6/1990 was itself null and void is accordingly set aside. With a clear observation that the right title and interest of Chandrika Singh arising out of the sale deed would essentially depend upon the partition of the joint estate of common ancestor Gokul Kumar, and certainly he cannot be held entitled to बस उतना सही हो जाएगा.
partition वो ओपन रहेगा किसका कितना शेयर होगा
इसीलिए बोलती है, नहीं तो फिर सब गड़बड़ हो जाएगा.
ये तो मुझे हाई कोर्ट has decided.
No, we have not decided.
No, that's right.
This court, it is made clear that the share of one or the other person in the family of Gokul Kumar will ultimately depend upon the partition. इसमें से कुछ जजमेंट्स हैं, लेकिन हम बिना जजमेंट देखे ऐसे साइड नहीं करते. हम I'll just see to these judgments. एक आध जजमेंट डाल देंगे. सेक्शन 44 का बहुत सारा जजमेंट्स है, ये निकाल नहीं पाए.
कैंसलेशन ऑफ सेल डीड का उतना चलेगा.
ठीक. हाँ, this appeal is accordingly disposed of.
पार्टी है
इससे क्या फर्क पड़ेगा आपको?
नहीं one part
Because there are so many things. हम खाली appellate court का judgment.
Two portion of law. One is against decided against me. The other is.
I've already said that the second substantial question of law is decided in your favor. वो तो हम बोल ही नहीं.
It is partly.
Sir, please, इससे कोई फर्क नहीं पड़ता. Because the appellate court has got many findings.
Many findings.
तो वो इसीलिए
Readings में नहीं था.
I have already said that the appellate court having set aside the sale deed is not sustainable. That part has to go.
Sale deed remains.
That sale deed
To the
remains.
extent of.
Yes.
Entitlement of the.
Yes, that will be subject to partition. That's it. To the next question.
Parcel case item 1, second appeal 120 of 1998.
Plaintiff's appeal against judgment of reverse.
All the plaintiffs are here.
Only plaintiff, only the sole plaintiff.
It is title suit.
Yes, title suit for declaration of right title interest in possession of the suit land and alternatively for recovery of possession as well as cost of the suit.
Okay, let us see the substantial question of law.
Substantial question of
Yes, section 17. Right? Where is the memorandum of partition and what is the
there is memorandum of
Exhibit
partition.
2, Lord Sir.
exhibit? It must have been exhibited.
Exhibit 2.
Exhibit 2 निकाल बस उतना ही सा तो है सेक्शन 17 और क्या है? पढ़िए ट्रायल कोर्ट का जजमेंट पढ़िए. Let us see the finding. हाँ जरूर से पढ़िए. बिना फैक्ट पढ़े कौन सा सेकंड अपील डिसाइड हो जाएगा.
उसके बाद आदमी द्वारा प्रतिवादी जन के विरुद्ध दाखिल किया गया कि विवादित भूमि खाता नंबर 34/35 स्थित मौजा असैदी थाना तमाड़ जिला रांची जिसका उल्लेख वाद पत्र की अनुसूची शेड्यूल में है पर मादनी का अधिकार स्वत तथा कब्जा दखल विरुद्ध प्रतिवादी गण के घोषित किया जाए. वादनी की यह भी मांग है कि उक्त विवादित भूमि पर अगर उसका कब्जा दखल नहीं पाया जाए तो उसे दिला दिया जाए. उसकी यह भी मांग है कि वाद का खर्चा दिलाते हुए न्यायालय की नजर में वादनी को किसी अन्य अनुतोष का अधिकारी पाया जाए तो उसे भी वादनी के पास में विरुद्ध प्रतिवादीगण के घोषित किया जाए. यहाँ उल्लेखनीय है कि वाद पत्र में दर्ज नाम प्रतिवादी संख्या 6 काली मातो, प्रतिवादी संख्या 7 कुंदन मातो तथा प्रतिवादी संख्या 11 रामजीवन मातो की मृत्यु वाद काल के दौरान हो गया जिसके कारण मृतक प्रतिवादी गण के स्थान पर उनके झाड़ एवं विधिक उत्तराधिकारी का नाम क्रमशः प्रतिवादी संख्या 6, 6A, 6B, 6C एवं 6D तथा प्रतिवादी संख्या 7 के स्थान पर 7
Exhibit 2.
के स्थान पर 7A, 7B, 7C का नाम प्रतिवादी संख्या 11 के स्थान पर 11A, 11B का नाम आदेश दिनांक 18/2/1892 के अनुसार वास्तव में दर्ज किया गया. वादनी का दावा का सारांश यह है कि विवादग्रस्त खाता नंबर 34/35 पूर्व में बुधराम स्वासी, जंगल स्वासी एवं हसिया स्वासी के नाम से दर्ज था. जंगलाल स्वासी तथा हसिया स्वासी की नावल मृत्यु हो गई तब एकमात्र उत्तराधिकारी बुधराम स्वासी को उक्त भूमि पर स्वत्वाधिकार तथा कब्जा दखल प्राप्त हुआ. उसके बाद जब बुधराम स्वासी की भी मृत्यु हुई तो उक्त भूमि पर उनके एकमात्र विधिक उत्तराधिकारी लड़का खुद एतवा स्वासी का नाम वरासतन आया और वे कब्जा दखल में आए और खेती बाड़ी करने लगे. कुछ समय बाद एतवा स्वासी वादिनी बठे देवी से शादी की और उसके बाद ही बुधनी देवी से भी शादी की. इस तरह दो पत्नी के साथ एवं बच्चों के साथ पूरी पूर्वक जीवन यापन करने लगे. पुनः वादिनी का कथन है कि एतवार स्वासी ने अपने दोनों पत्नियों एवं उनके बच्चे में भविष्य में कोई विवाद संपत्ति को लेकर नहीं हो यह सोचकर दोनों पत्नियों और उनके बच्चों के बीच खाता नंबर 34/35 में दर्ज जमीन से अलग अलग दो भाग में बंटवारा ग्राम पंचायत के मुखिया बाबरी पूरन, सरपंच मोहन पूरन, ग्राम पंचायत लंटू एवं अन्य ग्रामीणों के समक्ष 15/4/1967 को कर. उक्त बंटवारा लिखित पंचनामा द्वारा ग्राम पंचायत लड्डू थाना पंडितरी ग्राम परसदी थाना तमाल जिला रांची द्वारा किया गया, जिसका प्रमाणित प्रतिलिपि बंटवारा दोनों पत्नियों वादिनी एवं दूसरी पत्नी दुगनी देवी को मिला। तभी से दिनांक 15/4/67 से दोनों औरतें बंटवारा मिली भूमि खाता नंबर 34/35 पर अपने हिस्से प्रत्येक को आधा आधा पर काबिज दाखिल हुई तथा शांतिपूर्ण कब्जा दखल में चली आई। बंटवारा के अनुसार अपने हिस्से की जमीन का खारिज दाखिल म्यूटेशन वादनी करा लिया और बिहार सरकार को मालूम लगाना तय करने लगे। प्रतिवादी का अब दावा करते हैं कि विवादग्रस्त भूमि से वे सुखलाल स्वासी उर्फ एतवार स्वासी से पंजीकृत विक्रय द्वारा खरीद किए हैं, लेकिन वादनी का कथन है कि सुखलाल स्वासी एक दिगर व्यक्ति है जिसका कोई संबंध एतवार स्वासी से नहीं है और एतवार स्वासी का दूसरा कोई नाम सुखलाल स्वासी नहीं था और न ही उसे विवादित भूमि पर कोई स्वामित्व अधिकार था और न ही उसे उस भूमि को अंतरण करने का कोई अधिकार प्राप्त था। वादिनी द्वारा आगे यह भी कहा गया है कि एतवार स्वासी कोई जमीन प्रतिवादी को विक्रय नहीं किए हैं और न ही वे विक्रय करने के अधिकारी थे, क्योंकि वे अपने जमीन का बंटवारा।
सारा ये था कि the original owner of the property had divided the property in the legal heirs and successors of his two wives, and therefore he lost title over the property and therefore he could not have sold the property. That is the gist of the story, right? Finding बताइए. The defendants must have denied partition.
Yes,
completely.
yes, they have denied.
Yes. Then what happened? Issues में आई. Come to the issues.
Para 12 lots.
Para 12. हाँ पढ़िए.
वे बच्चों की सुनने पर प्रस्तुतिवादी निष्पादन विचार हेतु इशू गठन किया गया। क्या वादी का दावा दाखिल करने हेतु वाद कारण और ऑब्जेक्शन उत्पन्न हुआ? क्या वादी दावी
Issue number 4.
Yes.
क्या एतवार स्वासी वादग्रस्त भूमि का बंटवारा अपनी दोनों पत्नियों बधाइयों भूमि और उनके बच्चों को खाता नंबर 34/35 कर दिए और यादगार के लिए बंटवारा का लिखित दिनांक 15/4/67 को कर दिए एवं बंटवारा के अनुसार अपने अपने हिस्से पर कब्जा दखल दे दिए तथा कथित बंटवारा अमल में आया है और विवादग्रस्त भूमि में वादनी का स्वतंत्र अधिकार या हित निहित है।
Para 15 is the findings.
पढ़िए para 15. Yes.
प्रस्तुत वाद के निष्पादन हेतु निर्धारित सभी 6 बिंदुओं में वाद बिंदु संख्या 4 सबसे महत्वपूर्ण वाद बिंदु है जिसका निष्पादन प्रस्तुत किया जाता है। विवादित खाता संख्या 34/35 में दर्ज प्लॉट पर पुराना इंदिराज तो वादी अपने वाद पत्र के खंडिका 2 में दर्शाया है कि उक्त खातों का इंदिराज बुद्धराम स्वासी
कौन सा इशू नंबर कौन सा शुरू किया? 4.
इशू नंबर 4
ठीक है चलिए पढ़िए.
जगपाल स्वासी एवं घसिया स्वासी के नाम दर्ज है जिसका समर्थन संपुष्टि में प्रदर्शित नकल प्रतिलिपि RS खतियान खाता 34/35 दाखिल किए गए जिसके अवलोकन से उक्त तथ्य की संपुष्टि होती है। बुद्धराम स्वासी जंगल स्वासी तथा घसिया स्वासी में जगपाल एवं घसिया स्वासी नावल्द मर गए और उनके चल एवं अचल संपत्ति का एकमात्र उत्तराधिकारी वादिनी बुद्धराम स्वासी ही उक्त खाते की भूमि पर कब्जा दखल में आया जिसका उल्लेख वादनी अपने दावा के खंडिका 3 में किया है और पैरा 4 में कहा है कि बुद्धराम स्वासी के मृत्यु के बाद खाता नंबर 34/35 पर एकमात्र वारिस उनका लड़का एतवार स्वासी कब्जा दखल में आए। प्रतिवादी अपने जवाबदेही प्रतिवाद पत्र के खंडिका 24/25 में उक्त तथ्य को स्वीकार कर चुके हैं, लेकिन अपने जवाब के कंडिका 26 में वह कहे हैं कि बुधराम स्वासी की मृत्यु के बाद इतवार स्वासी उनका लड़का वारिस बतौर उत्तराधिकारी उक्त खातों से भूमि पर काबिल दाखिल हुआ, लेकिन इतवार स्वासी का एक दूसरा नाम सुखराम स्वासी
भी था।
सुखराम स्वासी अतः प्रतिवादीगण का कथन है कि इतवार स्वासी का दूसरा नाम सुखलाल स्वासी भी था, जबकि वादिनी के तरफ से कहा गया कि बुधराम स्वासी का एकमात्र लड़का उसका पति इतवार स्वासी ही थे, उनका दूसरा कोई सुखलाल स्वासी नहीं था। वादिनी का मुख्य रूप से दावा है कि इतवार स्वासी जो उसके पति के उनकी दो पत्नियों की, जिनमें एक वादिनी है, दोनों पत्नियों के बीच भविष्य में जमीन जायदाद को लेकर विवाद नहीं दिनांक 15/4/67 से पंचायत द्वारा मुखिया, सरपंच एवं ग्रामीणों की उपस्थिति को विवादित खाता संख्या 34 एवं 35 की संपुष्टि भूमि को दो भाग में अलग अलग बंटवारा कर दिया और तभी से वादिनी अपने हिस्से में प्राप्त भूमि खाता संख्या 34 एवं 35 पर खारिज दाखिल हुई और खारिज दाखिल कराकर मालगुजारी लगान देती जा रही है, जबकि प्रतिवादीगण का दावा है कि इतवार स्वासी और सुखलाल स्वासी ने खाता नंबर 34-35 की भूमि को उनके नाम से विक्रय पत्र सेल डीड पंजीकृत द्वारा विक्रय किया और दखल कब्जा दे दिया। तभी से वे लोग उक्त भूमि पर कब्जा दाखिल चले आ रहे हैं। वादिनी के तरफ से उक्त विक्रय पत्र के संबंध में कहा गया कि इतवार स्वासी ने कोई विक्रय खाता संख्या 34 एवं 35 की भूमि का प्रतिवादीगण से नहीं किया था और बंटवारा दिनांक 15/4/67 के बाद उनसे कोई विक्रय का आधार भी नहीं था, कोई अधिकार भी नहीं था। प्रतिवादीगण द्वारा दाखिल विक्रय पत्र जाली एवं फर्जी है, उक्त भूमि पर उनका कोई स्वतंत्राधिकार नहीं है। उभय पक्षों के कथनानुसार विवादित खाता 34 एवं 35 का इंदराज वरासतन इतवार स्वासी के नाम से था, लेकिन विवादित भूमि के बाबत उभय पक्षों के दावे पर
ठीक है, समझ गए। उसके आगे फाइंडिंग करिए। वेयर इज द फाइंडिंग?
पैराग्राफ 16 वादिनी और प्रतिवादी गण के दावे प्रतिदावे के आलोक में मुख्य रूप से यह प्रश्न उठता है, क्या इतवार स्वासी का कोई दूसरा नाम सुखलाल स्वासी ही है? क्योंकि प्रतिवादी गण स्पष्ट रहे कि इतवार स्वासी और सुखलाल स्वासी ही दर्ज काश्तकार बुधराम स्वासी के लड़का परासतन कब्जा दखल में आया और उसी से वे खाता नंबर 34 एवं 35 की भूमि का विक्रय लिए हैं। जो प्रदर्श लगायत प्रदर्श ए लगायत प्रदर्श ए लगायत प्रदर्श 10 को देखने से जाहिर है कि प्रदर्श A3, A4, A5, A6 को इतवार स्वासी पुत्र बुधराम स्वासी विक्रय पर पंजीकृत लिखे हैं तथा शेष प्रदर्श A, A2, A7, A8, A9 एवं A10 के सुखलाल स्वासी पुत्र बुधराम स्वासी विक्रय पंजीकृत लिखे हैं। ये सभी विक्रय पत्र सन 1978 से लगाकर 76 के बीच में लिखा गया है। उक्त विक्रय दस्तावेज प्रदर्श ए लगाकर प्रदर्श A10 में लिखे दावे इतवार स्वासी या सुखलाल स्वासी का दूसरा नाम दर्ज नहीं है, जबकि प्रतिवादी बखूबी जानता है कि इतवार स्वासी का दो नाम सुखलाल स्वासी भी है, तो दस्तावेज विक्रय लिखाने के समय क्यों नहीं विक्रय
फाइंडिंग दिखाइए,
दूसरा नाम भी दर्ज किया गया है?
फाइंडिंग दिखाइए। इस पॉइंट में क्या है, दूसरा नाम था कि नहीं? बताइए
29 page 41 of the judgment certificate of your judgment उपरोक्त विवेचना से स्पष्ट होता है कि एतबार स्वासी का कोई दूसरा नाम शुक्ला स्वासी नहीं है
पैरा नंबर
21
पैरा 21 कहाँ से कौन से पेज से शुरू
पेज 41 certified copy of
पेज 41 पेज 41 तो कुछ है ही नहीं
नहीं 41 नहीं
कहाँ पढ़े तुम
34 सर अपन 41 नहीं पेज 38 तक ही
ठीक है पैरा 21
जिस तरह वाद है ये इंटरनल पेज यहाँ से पढ़िए तो 33 से 21 नंबर पैराग्राफ
हम पर हाँ
उपरोक्त
विवेचना से
विवेचना
स्पष्ट होता है कि एतबार स्वासी का कोई दूसरा नाम शुक्ला स्वासी नहीं था तथा एतबार स्वासी की दो पत्नियां वादिनी दत्तई देवी एवं बुधनी देवी है वादिनी द्वारा यह भी साबित किया जा चुका है कि दोनों पत्नियों के बीच भविष्य में किसी प्रकार का विवाद या झगड़ा नहीं है तो एतबार स्वासी ने मुखिया सरपंच तथा ग्रामीणों के समक्ष अपनी संपूर्ण जमीन खाता नंबर 34 एवं 35 के प्लॉटों को प्रत्येक पत्नी को आधा आधा हिस्सा का बंटवारा कर दिया और कब्जा दखल भी दे दिया और यादगार के लिए पंचायत द्वारा दिनांक 5/4/1967 से ही बंटवारा दस्तावेज प्रत्येक के हिस्से का अलग अलग तहरीर करके दे दिए तभी से वादनी अपने बंटवारा में प्राप्त जमीन पर कब्जा दखल में आई तथा खारिज दाखिल कराकर बिहार सरकार का लगाम मालगुजारी अदा करने लगी अभिलेख पर उपलब्ध साक्ष्यों से भी यह साबित हो चुका कि बंटवारा दिनांक 15/4/67 सभी तभी से अमल में है और दोनों पत्नियां अपना खेती बाड़ी खान पान अलग अलग करती आ रही हैं उपरोक्त विवेचना से यह प्रमाणित हो चुका है कि विवादग्रस्त भूमि पर वादिनी अपने स्वत एवं हक एवं हित को पूर्णतः साबित किया है तथा यह भी साथ ही यह तथ्य भी प्रमाणित हो चुका
फर्स्ट
है कि
एपिलेट कोर्ट का फाइंडिंग
बंटवारा
बताइए
उसके अमल में आने के कारण
फर्स्ट एपिलेट कोर्ट का पॉइंट फॉर डिटर्मिनेशन बताइए
पैरा 8 नोट्स पॉइंट्स फॉर डिटरमिनेशन
पैरा 8 चलिए so far as point of law is concerned we are concerned with issue number 2 point of determination number 2 correct है नहीं
यस
whether the party accepted in evidence.
हाँ बताइए क्या फाइंडिंग है
पैरा 11 नोट्स
पढ़िए
On careful scrutiny of evidence used on behalf of both the parties discussed above, we find that plaintiff has proved exhibit 2 said to be the deed of partition. I have gone through the same deed, the recital of which is as follows. एतवार स्वासी साकिन पलाश हुई जिनके दो स्त्रियां उसने अपने जमीन को दोनों स्त्रियों को बांट देता है बंटवारा करते समय ग्राम पंचायत के मुखिया सरपंच लक्ष्मी नारायण सिंह अन्य एवं ग्राम के बहुत से व्यक्ति शामिल थे Thereafter, description of the land is given. It is not stated in this deed from which side the land is given to each co-wives. The plaintiff and a mere description of land is given. Thereafter, it appears that bears the signature of Etwar Swasi and also bears signature of Mukhya and Sarpanch and some other villagers. But this does not bear the signature of plaintiff and Gujri. Further, the original deed of partition was not executed by the plaintiff. When it is admitted by Sarpanch PW3 that original is in Gram Panchayat and he granted certified copy himself by seeing the original. Therefore, this certified copy could not be looked into as evidence only on the ground that the original has not been proved before the court. Therefore, before appreciating the evidence used by the defendant, it will be proper first to give finding whether plaintiff by his evidence has been able to prove his case. On the point of possession also I find that the plaintiff has failed to prove his possession over the land by witnesses as I have discussed above, that PW1 could not say plot number of land cultivated by plaintiff. PW4 has stated in para 8 of cross-examination that the plaintiff is resident.
Exhibit 2 is the partition deed.
Yes.
अब बताइए क्या बोले हैं?
PW1 could not. PW4 has stated in para 8.
You just tell us.
जी.
There are numerous reasons granted to disbelieve Exhibit 2. And also saying that even the area has not been earmarked. कुछ भी नहीं लिखा है. एक तो recital है पुराना partition का कि नया partition का, on the face of it is not clear.
नहीं. वो party this memorandum of partition is with respect to the land of father number 34 and 35.
That's right. Is it mentioned that 34 will belong to one and the 35 will belong to another?
In both it is mentioned that in both khata both the wives will have half and half share.
So
it is not dispute
half
amongst.
and half share में
It is
कहाँ हो?
not dispute between the two wives that I am in possession of this land and you are possession of this land. It is not. It is dispute with respect to the land with stranger. They
You
are
just
connected.
see the substantial question of law is referable to section 17 of the Registration Act.
Yes.
If this particular document is itself creating partition,
Yes.
half and half, then under such circumstances, is it not compulsorily registrable?
If by that document any partition is
Yes,
effected,
it is not a
then
recital of previous partition. What is the previous date of partition? Is it mentioned?
जरा सा हम देखेंगे।
हाँ, तो देखिए ना, आप दिखाइए। Show it to me. पढ़िए देखिए ही मत, साथ साथ पढ़िए भी। कोटेड है एपेलेट कोर्ट के जजमेंट में, देखिए शेड्यूल भी चेक करिए।
व्यक्ति सम्मिलित थे, बंटवारा के समय सम्मिलित थे, पास्ट टेंस में।
कब है, कब बंटवारा कब हुआ?
मेरा कहना है कि बंटवारा कभी हो, मेमोरेंडम उसके बाद।
मेमोरेंडम नहीं भाई, उसमें तो वो जो भी लोग थे उसमें उनका भी साइन है।
दोनों वाइफ का सिग्नेचर नहीं,
दोनों वाइफ का सिग्नेचर नहीं है, उनका भी साइन है। पंचायत क्या नाम है उनका?
पंचायत का तो सिग्नेचर है।
हाँ,
पंचायत के जितने अथॉरिटी थे उनका सिग्नेचर है। और प्लेंटिफ और को वाइफ्स का सिग्नेचर जरूरी नहीं था।
ठीक है, नहीं भी था, इससे
It was
क्या
not necessary. and on that ground it cannot be thrown aside. तो इसमें लिखते हैं कि ग्राम के बहुत से व्यक्ति सम्मिलित थे, तो बंटवारा पहले हुआ जिसका कि इन राइटिंग उसको डॉक्यूमेंट में लिख दिया और एतवार स्वासी का भी उसमें सिग्नेचर है, अदर पंचायत के मुखिया हैं, सरपंच है, उनका भी सिग्नेचर है। And this was given effect on 15/4/1967. And thereafter it is said that in the year from 1971 to 76 there are sale deeds in the name of defendants. That was executed by Sukhlal Swasi, and Sukhlal Swasi is none. Sukhlal Swasi is none. The husband of the plaintiff is Jharkhand Swasi, and he is no alias name or nickname Sukhlal Swasi. There is no document. On the other hand, the witnesses have proved that Jharkhand Swasi is the husband of the plaintiff who has no other name. Therefore, I will again go through the finding of the learned trial court. ट्रायल कोर्ट अपने जजमेंट में लिखे हैं पेज
जस्ट अ मोमेंट। जिसकी दो स्त्रियां हैं उसने अपने जमीन को दोनों स्त्रियों को बांट देता है। बंटवारा करते समय ग्राम पंचायत के मुखिया सरपंच बघई के मुंडा लक्ष्मी नारायण सिंह एवं ग्राम के बहुत से व्यक्ति सम्मिलित थे। एतवार स्वासी पिता सचिन सच प्लॉट का बंटवारा ही नाम है तो
जी।
By this document only this Batwara is giving effect. We will read the entire document as a whole. Batwara ही है।
वो लिखते हैं कि बंटवारा हो गया, क्या क्या बंटवारा हुआ, तो वहाँ पे लिखते हैं कि ब्लॉक नंबर 34 और 35 का बंटवारा किए।
प्लॉट का बंटवारा ऐसा नहीं लिख रहा है कि ये उसके बाद by this document the portions are marked to both of them by this document.
पोर्शन है उसमें सिर्फ
शेयर जो भी है शेयर ही है, बाउंड्री भी नहीं है, खाली शेयर है।
प्लॉट नंबर इतना में ही आधा इतना में आधा
बंटवारा लोगों का हस्ताक्षर एवं अंगूठे का निशान। तो बंटवारा लोगों का हस्ताक्षर अंगूठे का निशान तो बंटवारा ही तो है।
अब उसके हिसाब से नहीं,
उसी के हिसाब से चले। जो डॉक्यूमेंट है वही। It is not memorandum of partition. This itself is giving effect to partition, wherein the persons of some villagers have also signed.
Yes.
The mukhia or whatever has also signed.
Deed of partition which is required to be registered according to section.
Even no date of previous partition has been mentioned. कि कब हुआ, कितना दिन पहले, 1 महीना पहले हुआ, 2 महीना पहले हुआ, ये भी नहीं लिखा है कि बंटवारा मौखिक बंटवारा के तहत दोनों जने अपने अपने एरिया के पोजीशन में हैं, ऐसा भी नहीं, वो भी नहीं। इसमें भी कोई बाउंड्री वो सब तो नहीं है, ठीक है। बंटवारा का क्या मतलब है? व्हाट इज बंटवारा?
बंटवारा मेरा सबमिशन है, इट इज नॉट ए बंटवारा, रादर बंटवारा नामा।
हाँ, what is
memorandum of
just a
partition।
moment, what is partition? Maybe
वो अपने लाइफ टाइम में whatever the region was there, he अपने Swasi in his lifetime has partitioned this property amongst both the wives. There may be some
and relinquish his right completely.
yes.
That
Yes,
relinquishment also requires registration.
Correct.
So if a person is relinquishing his right with respect to a property, even that relinquishment requires registration.
So it is not a document of relinquishment, rather it is a memorandum of partition.
Of
which
whose
has
property?
taken- Of his property, which he was possessing by virtue of the
Partition co-owners के बीच में होता है ना.
Yes.
So he is also the co-owner of the property? No. He is the co-owner of the property?
Yes.
He is partitioning it amongst his two wives.
Amongst his two.
Right. And giving up his share completely. उनको कोई right नहीं है, as per this. Correct?
लगता है कि हम अपने जीवन काल में दोनों को दे दिए, चूंकि भविष्य में किसी तरह की कोई परेशानी, किसी तरह का झंझट ना हो।
पार्टीशन में अगर मान लीजिए कोई प्रॉपर्टी का पार्टीशन होता है, इस प्रॉपर्टी का आधा आधा मिलेगा, इसका क्या मतलब है? इज इट पार्टीशन? डज दैट अमाउंट टू पार्टीशन? ये तो पता ही है सबको कि दो भाई है तो आधा आधा मिलेगा।
नहीं, यहाँ भाई का सवाल
भाई का नहीं, हम इन जनरल बोल रहे हैं,
यहाँ
जहां पर कोई बाउंड्री नहीं, बिकॉज दैट इज अनदर रीजन व्हाई द एपेलेट कोर्ट हैज सेड दैट दिस इज नॉट अ पार्टीशन. This is only one of the reasons that it is not a registered document and not admissible in evidence, right? There are multiple reasons to hold that this is not a partition.
उस पॉइंट पे रजिस्ट्रेशन इज whether this document
Yes, yes.
is admissible or not. Tomorrow I will suggest.
Tomorrow कुछ जरूरत नहीं. आपको क्या बोलना है?
Yes. Lordship, may at least
पहले कुछ फाइंडिंग देख लिया जाए, ट्रायल कोर्ट के फाइंडिंग को।
हाँ. कौन सा पैराग्राफ पढ़ना चाहते हैं ट्रायल कोर्ट का?
ट्रायल कोर्ट के जजमेंट का पैरा 20।
ट्रायल कोर्ट में इसके रजिस्ट्रेशन के बारे में लिखा है क्या?
नहीं,
हम बताते हैं, पढ़ दो।
पैरा नंबर
वादी ऊपर पैरा नंबर 16, वादनी और
पैरा
प्रतिवादी
नंबर?
के दावे पैरा 16 के
आप सीधे फाइंडिंग में आइए ना, इतना लंबा लंबा पैराग्राफ।
सेकंड के लिए राइट टू प्रॉपर्टी है, थोड़ा सा तो समय दीजिए।
समय तो दे ही रहे हो, 1998 से समय ही दे रहे हैं।
1998 से हमने
अरे
ऐसा
इसको
नहीं
कब
है कि
तक-
हम ही इसको लिंगर किए हैं। आई हैड फाइल्ड
कोर्ट इज अ पार्टी, जस्ट अ मोमेंट, कोर्ट इज अ पार्टी टू इट। अब नहीं रहेगा कोर्ट पार्टी आपके एडजर्नमेंट्स के लिए।
आई हैड
ठीक है?
फाइल्ड अ पिटीशन फॉर अर्ली
We are sorry to the litigant that we have not decided this case since 1998.
So some
No time is required for that. You say that you had filed an application for early hearing.
yes
Early
I had
hearing कर
filed. It was filed
Early
in the year
hearing कर रहे हैं आपका।
2007।
तब से पेंडिंग है ना?
Yes.
वही अर्ली हियरिंग कर रहे हैं आपका।
Okay.
2007 का पिटीशन कितना साल बाद हम आपका टेकअप कर रहे हैं, उसी का अर्ली हियरिंग हम कर रहे हैं।
मेरा पिटीशन आइए फाइल किए थे
1991 का पार्टीशन सूट आपको बहुत टाइम दे दिए हैं।
इट इज नॉट ए सूट फॉर पार्टीशन,
चलिए,
इट इज सूट फॉर टाइम।
दैट्स इट।
लॉ पॉइंट पे कल हम बात करेंगे।
नहीं
हाँ।
आज
कल
एडजर्न नहीं
शाम-
होगा, पिछले 2 बार से आप ही के ग्राउंड पे एडजर्नमेंट
हमारे ग्राउंड में हो सकता है कि हमारे ग्राउंड में होता टाइम लिया गया हो, लेकिन हम ऐसा नहीं कि ओमनी प्रेजेंट हो सकते हैं। मेरी वाइफ अगर बीमार रहेगी तो केस छोड़ सकते हैं।
हम आपको इसी ग्राउंड पे टाइम दिए
जी।
थे और आपके काउंसिल ने जितना टाइम मांगा था उतना टाइम आपको दिए थे, ठीक है?
हम कभी अवॉइड नहीं कर रहे हैं।
अवॉइड नहीं कर रहे। आइटम नंबर 1 है
जी।
एडवांस नोटिस फॉर एडजर्नमेंट क्यों नहीं देते? मना किया है आपको।
अब तो फर्स्ट हाफ में बोले
बस फर्स्ट हाफ सेकंड हाफ का कहानी मत सुनाइए।
अगर
हम इतना देर से आपको सुन रहे हैं, अब आप चलिए। कहाँ है फाइंडिंग फर्स्ट ट्रायल कोर्ट? बताइए कौन सा फाइंडिंग आप पढ़ना चाहते हैं?
मैं पैरा 16 से पढ़ेंगे।
अच्छा पढ़िए,
वादनी और प्रतिवादी का
तेजी से पढ़िए, एकदम तेजी से।
वादनी और प्रतिवादी के उनके दावे प्रतिदावे के आलोक में मुख्य रूप से यह प्रश्न उठता है क्या एतवार स्वासी का कोई दूसरा नाम सुखलाल स्वासी है, क्योंकि प्रतिवादी का स्पष्ट रहे कि एतवार स्वासी और सुखलाल स्वासी ही दर्ज काश्तकार बुधराम स्वासी का लड़का बरासतन कब्जा दखल में आया और उसी से वे खाता नंबर 34/35 की भूमि का विक्रय लिए जो प्रदर्श नंबर 67 से है। उक्त विक्रय दस्तावेज प्रदर्श 1/10 में लिखते हैं कि दावे एतवार स्वासी या सुखलाल स्वासी का दूसरा नाम दर्ज नहीं है। जब प्रतिवादी बखूबी जानता है कि एतवार स्वासी का दो नाम सुखलाल स्वासी भी है तो दस्तावेज विक्रय लिखवाने के समय क्यों नहीं विक्रय पत्र में दूसरा नाम भी दर्ज किया गया। यह तथ्य एक संदेहात्मक स्थिति दस्तावेज की सत्यता से संबंध में प्रकट करता है। प्रतिवादी गण द्वारा प्रस्तुत किए गए साक्षीगण संख्या 1/32 जिसमें कुछ प्रतिवादीगण तथा दखल कब्जा एवं औपचारिक साक्षीगण हैं, जिसमें इनमें से किसी ने भी नहीं प्रकट कर सके कि एतवार स्वासी का दूसरा नाम सुखलाल स्वासी किसी कागजात में दर्ज देखा। यहाँ तक कि प्रतिवादी साक्षीगण ने भी स्वीकार किया कि एतवार स्वासी का दूसरा नाम सुखलाल स्वासी का इंदराज किसी कागजात में नहीं देखा है। ऐसी स्थिति में जो डॉक्यूमेंट लिए हैं सुखलाल स्वासी से, कैन इट बी सेड टू बी ए वैलिड डॉक्यूमेंट? इस स्थिति में विवादित खाता संख्या 34/35 की भूमि की सुखलाल स्वासी द्वारा विक्रय करना उक्त दस्तावेज की वैधता पर प्रश्न चिन्ह लगाता है। प्रतिवादी गण से स्पष्ट प्रमाणित करना चाहिए था कि एतवार स्वासी का दूसरा नाम सुखलाल स्वासी भी है, लेकिन उक्त तथ्य से केवल मौखिक साक्ष्य द्वारा मात्र कह देने से प्रमाणित नहीं किया जा सकता। जबकि सरकारी कागजातों में अगर एतवार स्वासी का नाम सुखलाल स्वासी भी है तो बहुत से इंदराजों में मिल सकता था, लेकिन ऐसा कोई कागजात अभिलेख पर प्रतिवादी गण द्वारा नहीं दाखिल किए गया। ग्रामीण एवं पंचायत के सरपंच एवं मुखिया रह चुके वादी साक्षी संख्या 3 चंद्रमोहन पूरन ने पैरा 7 परीक्षण में स्पष्ट इनकार किए कि एतवार स्वासी का दूसरा नाम सुखलाल स्वासी भी था। यह तथ्य जाहिर हो चुका कि खातेदार मृतक बुधराम स्वासी का एकमात्र लड़का एतवार स्वासी ही था। So this burden was upon the plaintiff to prove that एतवार स्वासी had no other name or surname like Sukhlal Swasi, and witnesses have also came forward to say. Then onus shifted upon the defendant to prove that Etwar and Sukhlal is one and same person. They are possessing the document.
That is not the substantial question of law. You focus on the substantial question of law. जो बनवाए हैं उस पर बहस करें।
It is judgment of reversal.
हाँ तो बनवाए हैं ना आप substantial question of law. Case admit हुआ on the substantial question of law. You focus on substantial question.
So judgment of reversal and liberty was also there to raise any other substantial question of law. जबकि सरकारी कागजातों में अगर एतवार स्वासी का नाम सुखलाल स्वासी भी है तो बहुत से इंदराजों में मिल सकता था, लेकिन ऐसा कोई कागजात अभिलेख पर प्रतिवादी गण द्वारा नहीं दाखिल किया गया। ग्रामीण एवं पंचायत के सरपंच एवं मुखिया रह चुके ने अपने परीक्षण में स्पष्ट इनकार किया कि एतवार स्वासी का दूसरा नाम सुखलाल स्वासी भी है। यह तथ्य जाहिर हो चुका है कि खातेदार मृतक बुधराम स्वासी का एकमात्र लड़का एतवार स्वासी ही था। इन तथ्यों के विवेचना के आलोक में खाता नंबर 34 एवं 35 के भूमि का कोई स्वत्वाधिकार सुखलाल स्वासी को प्राप्त नहीं था और उक्त बिंदु पर उनके द्वारा किया गया विक्रय पत्र बिल्कुल अवैध तथा विधि विरुद्ध था। वादनी के तरफ से यह भी कहा गया कि प्रतिवादीगण का कोई विक्रय पत्र विवादित खातों के भूमि का एतवार स्वासी वादनी के पति द्वारा कभी नहीं किया गया, बल्कि वे लोग वादनी को असहाय सब अनपढ़ जानकर उसकी भूमि को हड़पने के लिए जाली एवं बनावटी विक्रय पत्र एवं साजिश के अंतर्गत किसी दूसरे व्यक्ति
अपने हस्बैंड को पार्टी बनाए थे
जी
अपने हस्बैंड को पार्टी बनाए
नहीं।
थे? क्यों नहीं बनाए थे? उनका सेल डीड एग्जीक्यूट किया हुआ चैलेंज करेंगे, उनको पार्टी नहीं बनाएंगे?
उनका हम तो कह रहे हैं उनका नहीं किया हुआ है,
तो कौन बताएगा उनका किया हुआ है कि नहीं है?
जो परचेज किया सो बताएगा।
जी नहीं, जो एग्जीक्यूट किया है वो बताएगा।
उस इशू पे कहीं हमारा सूट डिसाइड नहीं हुआ है कि नॉन वेंडर ऑफ पार्टी, और ट्रायल कोर्ट के फाइंडिंग को लोअर एपीलेट कोर्ट व्हाइल रिवर्सिंग द फाइंडिंग हैज नॉट असाइन्ड एनी रीजन ऑन दिस पॉइंट। इसलिए रिक्वेस्ट है कि कल पे रखिए, लॉ पॉइंट पे थोड़ा सा बात करेंगे।
आपको क्या बोलना है?
Yes, Lord, may I kindly see page 34 of the judgment of learned trial court, Lord. Now see, the plaintiff filed title suit for declaration of his right title interest and in the alternative for recovery of possession. But no relief was claimed for cancellation of sale deed. But the learned trial court, Lord, has declare the sale deed executed by the Etwari Swasti in favor of the defendant null and void, Lordship.
There was no relief to that.
No relief. No relief. Lordship, may kindly see page para 34, Lordship. नीचे से 9 लाइन हम पढ़ रहे हैं, नीचे से पेज 34। सोमासी या सुखलाल सोमासी को कोई हक अधिकार प्रतिवादी के पास विक्रय पत्र केवला करने का नहीं था। साक्ष्यों से स्पष्ट है कि प्रतिवादी गण के केवला संदेहात्मक है, जिसके कारण वादी कथन है किसी अन्य व्यक्ति को खड़ा करके जाली और फर्जी विक्रय पत्र चुपके से करा दिया गया है। संपुष्टि इस तरह वादी ने अपने दावे को स्थापित करते प्रमाणित कर दिया है कि प्रतिवादी गण अवैध तथा शून्य करार करने के योग्य है। ऐसी स्थिति में विवादग्रस्त भूमि खाता संख्या 34 और 35 के प्लॉट के बाबत प्रतिवादी के विक्रय प्रभावी अवैध एवं शून्य करार दिया जाता है। नो रिलीफ वाज प्लेड लॉट मेकनली सी लॉर्डशिप ऑर्डर 7 रूल 7 ऑफ द सीपीसी लॉर्डशिप।
You see, the appellate court has recorded a finding of non-joinder of necessary facts.
Yes.
Therefore, that finding stands concluded.
Yes.
The appellate court has recorded that the vendor of the sale deed was not a party for no reasons,
No
right? And he appears to be the husband of the plaintiff,
Lord,
right? Neither party है ना उनका गवाही हुआ,
कुछ नहीं,
कोई लेना देना
कुछ
नहीं
नहीं।
है उनसे, ठीक है? इसीलिए इस बात का कोई मतलब नहीं।
कोई मतलब नहीं।
Substantial question of law सिर्फ बना है
Then Lord,
डॉक्यूमेंट
behind
पर।
the two judgment lordship with regard to section 17 lord. Para 13 lord. Para 13 lord. It is a not a memorandum of partition, it is a deed of partition. According to section 17(1)(b), it is required to be registered lordship. In Nani Bai versus so and so, it is held by the court that though the partition among the Hindus may be effected orally, if the parties reduce in it writing to formal document which is intended to be evidence of parties, it would have the effect of declaring the exclusive title of the co-partner to whom the particularly property was allotted. In part, thus the document would be required to be compulsory registered lord. It is not a memorandum of partition, it is deed of partition which is required to be registered lord. So this is my suggestion.
And apart from that, the learned trial court, the appellate court has also recorded that this partition is not earmarking any share.
Yes.
It is only saying half share.
Half share.
Half share means what? That is always there, half share.
Lord sir.
Or whatever be the share of the co-owners or whatever.
Yes.
But that reason has also been given by the learned first appellate court, apart from section 17. This is the case of Roshan Singh versus Zile Singh and Siromani versus Hem Kumar has been considered.
The whole
Right.
case of the plaintiff is Exhibit 2 lordship, and Exhibit 2 is a unregistered document lordship.
No, what I want to say is that apart from registration or non-registration of Exhibit 2, the deed is not earmarking the share.
Yes.
And this is one of the reasons taken by the learned trial court to say that it is not a deed of partition.
Yes.
Apart from that, the court has also considered that it is unregistered and therefore it is not admissible in
Admissible
evidence.
in-
So Exhibit 2 as a deed of partition or recital of partition or recital of earlier partition is rejected on two distinct grounds.
Lords.
So far as the other distinct ground is concerned, there is no substantial question of law, and on the face of the document it is just half and half share.
Yes. This is my submission.
Second appeal number.
I have two judgments.
दीजिए.
So far the objection that it is not signed by the.
We are not bothered about that objection.
Yes.
We don't care about that objection.
And so far the finding that the learned trial court has declared the document as null and void. When the document itself ab initio void, there requires no declaration. In view of the judgment reported in 2006, volume 5, Supreme Court cases 353, para 16.
Prem Singh.
Yes.
Prem Singh, na?
But lordship,
Vendor is not a party. Where are you? Vendor is not challenging.
There is no evidence that whether vendor was alive or not.
What do you mean, no evidence? Did you say that he has expired and therefore he is not a party? Vendor is not a party.
When property is, my contention is this.
अब हस्बैंड का प्रॉपर्टी ले लिया, अब हस्बैंड से क्या लेना देना? यही बोलना चाह रहे हैं आप? Your husband is a vendor?
हम तो ऐसा नहीं बोल सकते।
तो फिर क्या बोल रहे हैं आप?
अब ये कहीं एविडेंस में नहीं आया।
हो गया, ओवर. कुछ है नहीं सर, ऐसी बात नहीं है कि हम टाइम नहीं देते हैं, लेकिन कुछ हो भी तो टाइम देने के लिए. आप बताइए, पूरा दिन में आपका सेकेंड अपील मुश्किल से 2 केस डिस्पोजल होता है, फिर कोर्ट बोलेगा कोर्ट तो कोई काम ही नहीं कर रहा है, कोई दिन एक केस भी डिस्पोजल नहीं हो पाता है. आपको मालूम है? डू यू अंडरस्टैंड?
डिस्पोजल बहुत
This-
जरूरी नहीं है, जस्टिस
नहीं बहुत जरूरी है, इसीलिए जस्टिस ही करने के लिए ऑर्डर करते हैं.
डिस्पोजल जरूरी है। हमारा तो कहना था कि ऑर्डर्स और ऑर्डर 41 पहले सुनते, 4 बजे से हियरिंग के सुनते,
आप हमारा बोर्ड नहीं डिसाइड करेंगे.
हम
सुप्रीम कोर्ट का डायरेक्शन है कि टारगेटेड केस को करना है, तो ये मेरा प्राइम रिस्पॉन्सिबिलिटी.
हम लोग के साथ कुछ एडमिशन केसेस इधर उधर
आप जो 2016 का अभी तक सब्सटैंशियल क्वेश्चन ऑफ लॉ नहीं बनवाए हैं, तो उसके लिए हम जिम्मेवार हैं. चलिए, कहानी हमको मत सुनाइए. आपका 2016 का 3 बार डिसमिस फॉर डिफॉल्ट होकर रेस्टोर हो चुका है केस. गलत है बोल, ऐसा थोड़ी है.
ऐसा पहले तो है कि आप इस कोर्ट के बाहर तो नहीं रह ही सकती।
हाँ, तो यहीं से हम लोग को पता है, रिकॉर्ड भी देख रहे हैं. Second appeal number 120 of 1998 within bracket R. Heard the learned counsels appearing on behalf of the parties. हम बस एक ही चीज़ बोलना चाह रहे हैं, मेरा जजमेंट गलत हो उसको सेटिसाइड करा दीजिए, लोगों का मरने का वेट मत करिए.
ठीक है,
बस.
मेरा भी
This
एक
is
बात
my
कहना है।
concern.
मेरा
देखिए,
कहना है,
This appeal has been filed.
लिटिगेंट ऐसा कितना पुअर है कि लीगल
पुअर को और पुअर मत बनाइए.
एड से कोर्ट फी माफ कराए।
I know we are from Jharkhand.
सुप्रीम कोर्ट जा सके,
क्यों नहीं जा सकेगा? फ्री लीगल एड मिलता है. क्या बात बोल रहे हैं आप? सुप्रीम कोर्ट नहीं जा पाएगा. ये सब जमाना अब चला गया कि गरीब आदमी सुप्रीम कोर्ट नहीं जा पाएगा. खाली आप जैसा वकील होना चाहिए उनको बताने के लिए कि रास्ता कहाँ से है. रास्ता है ना, तो भेज दीजिए. अब वकील साहब क्यों बोलेंगे लीगल एड में जाइए? वकील साहब अपना फीस मांगेंगे. ये हम भी कराएंगे सुप्रीम कोर्ट में। सुप्रीम कोर्ट में फाइलिंग में भी आपका एविडेंस ट्रांसलेट कराते कराते आपका 50,000 रुपये खर्चा हो जाएगा, इसीलिए लीगल एड भेज दीजिएगा, उसी में फाइल। This appeal has been filed against judgment and decree dated 30/7/1998 within bracket decree signed on 7/8/1998 entitled appeal number 32 of 1995 by the learned 8th additional judicial commissioner Ranchi, whereby the judgment and decree, the judgment dated 10/3/1995 within bracket decree signed on 22/3/1995 in title suit number 6 of 1991 has been set aside and the suit has been dismissed. The plaintiff is the appellant before this court. आप एक चीज देखे हैं, लेट को भी काटा हुआ है, उसको आप बोलते हैं मरे हैं कि जिंदा है पता नहीं।
लेट को इसलिए काटा,
कॉस्ट टाइटल में भी कटा हुआ है, लेट टाइप किया हुआ को भी काटा हुआ है,
इसलिए कि वही डिफेक्ट निकलता है। डिग्री में अगर
डिफेक्ट
नहीं है,
निकलेगा तो आप कुछ भी कर देंगे।
डिग्री में अगर नहीं है तो बोलेंगे कि ये गलत है, गलत नहीं।
This appeal was admitted for final hearing by the order dated 21/1/2000 on the following substantial question of law. The records of the case reveal that the suit was filed for declaration of right, title, interest and possession with respect to the suit land whose details have been mentioned in the schedule to the plaintiff. A prayer was also made that if the plaintiff is not found in possession of the property, then she may be put in possession. It was the case of the plaintiff that the suit land devolved upon Buddharam Swasi and thereafter upon her only son Etwar Swasi, who was minor at the relevant point of time, at the time of death of his father. Etwar Swasi came in possession of the suit land and cultivated the same, and in course of time he married twice. The two wives were the plaintiff and one Budini Devi. Both the wives of Etwar Swasi have sons and daughters. It was further case of the plaintiff that Etwar Swasi, during his lifetime, divided his land between his two wives. With respect to land in Khata number 35 in two portions, and allocated 4 kattha, 1 pehla to each his wife. The partition took place before Mukhia and Sarpanch of Lungtu Gram Panchayat and in presence of some other villagers on 15/4/1967. A document was prepared in evidence of the said partition. The document was recorded in Lungtu Gram Panchayat and certified copy of the said document were issued to each wife of Etwar Swasi, and the respective portion of the land were given to them. It was the case of the plaintiff that 2 wives were put in possession since 15/4/1967. The case of the plaintiff was that she, being the wife, one of the wife, was allotted land in partition and resumed possession, got her name mutated in Sarista of the state, and has been paying rent since then. And therefore, she was the exclusive owner of the suit property. On the other hand, the defendants claimed to have purchased the land from one Sukhlal Swasi alias Etwar Swasi. The plaintiff denied by registered sale deed. The plaintiff denied that Etwar Swasi had any alias name as Sukhlal Swasi. The plaintiff further alleged that the sale deed, if any, filed by the defendant, the same is false and fabricated document in the name of Sukhlal Swasi, and it was never signed by Etwar Swasi. The plaintiff also admitted that the proceeding under section 145 CRPC launched by her was decided against her, and the defendants were found in possession over the land by the Court of Executive Magistrate. On the other hand, the case of the defendant was that the plaintiff had not made her husband Etwar Swasi alias Sukhlal Swasi party in the suit, who was a necessary party. According to the pleadings of the plaintiff, it was the defendants were claiming property through registered sale deed, and therefore they stated that the vendor was a necessary party, who was the husband of the plaintiff. They had purchased the property by paying valuable consideration, and the sale deed was registered on 19/6/1973. Further, Karam Singh Mehto, the defendant number 5, according to the defendants, on 17/4/73, the father of defendant number 1 to 4 purchased 33 decimal of land from Sukhlal Swasi, and defendant number 5 purchased 25 decimal of land from Etwar Swasi for valuable consideration through registered sale deed. One Karamchand had also purchased land through registered sale deed from Etwar Swasi. Other description of sale deeds were also given by the defendant. The further case of the defendant was that the deed of partition was not genuine and it was created for the purposes of grabbing the land which was already sold by the husband of the plaintiff. The trial court framed the following issues for consideration. First appellate court का ही judgment में issues मिले. The learned trial court. आप लोग जिसको जाना है आप लोग जा सकते हैं, हम लिखा के उठेंगे. आपको भी जाना है, आप भी जा सकते हैं, आप लोग दोनों भी जा सकते हैं. नहीं, मर्जी है, ऐसी कोई बात नहीं. Everybody may leave. I'll just complete this dictation and then. Sir, please बीच में disturb मत करिए. I'm in the midst of a dictation.
Cause को माफ कर दो. We will amend our.
Sir, please आपको बोले ना disturb नहीं करिए. The trial court decided issue number 4 by holding that the plaintiff had right, title and interest over the suit land, and that while deciding issue number 1, the plaintiff had valid cause of action. The court also decided that issue number 2 and 3 was not barred by limitation. And the court decided that issue number 5 and 6, that the plaintiff was entitled for the relief as prayed for. The learned trial court held that the plaintiff got the property by virtue of Exhibit 2 and came in possession of the property after mutation, and the partition between the two wives came into effect on 15/4/1967, and therefore the plaintiff had the exclusive right, title and interest over the suit property. The learned trial court also recorded that the learned trial court ultimately recorded in paragraph 21 that Etwar Swasi did not have any other name as Suklal Swasi, and that Etwar Swasi had two wives, Baghai Devi and Budhni Devi. The plaintiff proved that there was partition so as to avoid future conflict between two wives, and that Etwar Swasi divided the properties in khata number 34 and 35 amongst two wives, and by virtue of the partition deed dated 15/4/1967, and since then the plaintiff has been in possession of the property and has been paying rent to the state. The learned court held that the learned trial court held that Etwar Swasi or Suklal Swasi had no right to sell the suit land. And further held that as the property was already partitioned, the learned trial court held that the sale deed relied upon by the defendants was doubtful, and the plaintiff has been able to prove that the sale deed was executed by getting another person in place of her husband, namely Etwar Swasi. The learned trial court declared the sale deed as null and void and not binding on the plaintiff. And ultimately decreed the suit. By holding that, they ultimately decreed the suit. So far as the learned first appellate court is concerned, the following points for determination were formulated. Paragraph 8. The learned first appellate court, while deciding issue number 4, held that since the partition itself was not proved in accordance with law, and the court had held that the deed of partition required registration, the appeal was fit to be allowed. The learned court also recorded that Edward Swasi was a necessary party to the suit. And the suit was bad for non-joinder of missing party. The learned first appellate court, while considering the point number 3, held that the plaintiff has to stand on his own leg, and also recorded that the trial court had disbelieved the execution of the sale deed by Edward Swasi, but did not consider that the exhibit 2, that is the deed of partition, was not admissible in evidence, and held that the learned trial court completely erred in giving finding that the plaintiff had right title and interest over the suit land. The learned first appellate court also took into consideration that the exhibit 2 only should be taken into consideration for the purpose of declaring right title and interest over the property, and not proving the defendant's case could not declare the title of the plaintiff. So far as the point number 2 is concerned, the learned court recorded that the exhibit that the exhibit 2 revealed that the deed of that it was deed of partition, and the partition was effected by the said document, and therefore it required registration, and it was not admissible in evidence. Moreover, the deed of partition did not bear the signature of the plaintiff and the deed. By deciding the point of determination number 1, the learned court held that the plaintiff failed to prove his possession over the land The PW1 could not say the plot number of the land cultivated by the plaintiff. PW4 stated in paragraph 8 of the cross-examination that plaintiff is residing with Etwar Swasi, and he is cultivating the land with her husband Etwar Swasi. It was also stated that 6 Kattha 1 Pehla is in their possession, whereas the plaintiff herself said that she was in possession of 3 Kattha 10 Pehla. The learned First Appellate Court, upon considering the materials, held that the plaintiff has not been able to prove possession over the suit land, and the plaintiff failed to adduce evidence on the point of title, and Exhibit 2 was not admissible in evidence. The learned First Appellate Court also quoted the recital of Exhibit 2 and also recorded that even the description of the land mentioned therein was not, but it only contained the description of land. It also was having the signature of Etwar Swasi and also the signature of Mukhia and Sarpanch and some other villages. The finding is recorded as under para 11. The learned First Appellate Court ultimately set aside the judgment and decree passed by the learned trial court and dismissed the suit. The learned counsel for the appellant, while referring to the substantial question of law as framed, has submitted that the perusal of Exhibit 2 would reveal that the same was apparently a memorandum of partition which had taken place earlier between the two wives of Etwar Swasi, which was divided between the two by none less than Etwar Swasi, and therefore it did not require registration under Section 17 of the Indian Registration Act. He has submitted that the learned trial court has recorded that the deed was executed by Etwar Swasi alias Suklal Swasi, and Etwar Swasi did not have the alias name as Suklal Swasi. And on this ground, it was held that the deed executed in favor of the defendants by Etwar Swasi alias Suklal Swasi was doubtful, and consequently the same was rightly set aside. The learned counsel has submitted that the deed was executed through impersonation by making a third party stand in place of Etwar Swasi, and therefore it was null and void, and once the deed is null and void, there is no need to specifically challenge the same. He has relied upon the judgment passed by the Honorable Supreme Court in the case of Prem Singh, paragraph 16.
एक जजमेंट
The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 1975 bracket rule 1 SCC 556 para number
6 and 7
para number 6 and 7
with respect to admissibility of that
with respect to admissibility of exhibit 2 and has submitted that considering the and has submitted that considering the nature of exhibit 2, the same did not require registration and accordingly the substantial question of law is fit to be answered in favor of the appellant and against the respondents, and the impugn judgment passed by the learned first appellate court is fit to be set aside. The learned counsel for the respondent on the other hand has opposed the prayer and has submitted that the husband of the plaintiff was neither made party nor examined, nor the sale deed executed by him was challenged before the learned court. The learned counsel submits that the plaintiff alleged impersonation, but there is no explanation as to why Atwar Swasi was not made party and why the sale deed itself was not challenged. He has submitted that the point as to whether a deed is executed by impersonating is itself a question of act and law, and therefore it was required to be challenged, specifically challenged in accordance with law. He has submitted that the judgment passed by the Honorable Supreme Court in the case of Prem Singh does not help the appellant in any manner.
I want to reply, Lord. AIR 2010 SC. I'm sorry,
AIR
2010 SC, page 211, Lord. In Abdul Rahim.
The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in AIR 2010 SC 2011. Abdul Rahim,
in which the Honorable Supreme Court held that any registered document, either void or voidable, which is required to be challenged before the court.
and has submitted that any registered document, either void or voidable, is required to be challenged as there is a presumption of correctness in connection with the execution of a registered deed of sale. The learned, however, so far as the substantial question of law is concerned, the learned counsel has submitted that the Exhibit 2 clearly reveals that the same is by itself is partitioning the property half and half with respect to plot khata number 34 and 35. But even in this deed, the exact area is not mentioned. The learned counsel has submitted that the learned trial court has also referred to this document by saying that by virtue of this particular deed, the partition was effected and thereafter they started having their own share. The learned first appellate court has recorded that, has disbelieved this document and recorded the same as inadmissible in law. He has relied upon the judgment passed by the Honorable Supreme Court in the case reported in bracket 2014 bracket close 12 SCC 189. Paragraph 13 to submit that though partition amongst Hindus may be effected orally, But if the parties reduce it in writing to a formal document which is intended to be evidence of partition, it would have the effect of declaring the exclusive share of the co-partner to which a particular property was allotted in partition, and the same is compulsorily registrable under section 17 within bracket 1 within bracket B of the Registration Act. He submits that the plaintiff has relied upon Exhibit 2 to show that it was a document of partition,
It is not a memorandum of partition.
and it was never the case of the plaintiff also that it was a memorandum of partition, and otherwise also on the face of Exhibit 2 it is not a memorandum of partition, and therefore it was compulsorily registrable. And in view of the judgment reported in 2004 12 SCC 189, the Exhibit 2 is hit by section 17 of the Indian Registration Act. The substantial question of law according to him is fit to be answered in favor of the respondent, and the appeal is fit to be dismissed. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and upon perusal of Exhibit 2, this court finds that the Exhibit 2 itself is seeking to divide the property between the two wives of Atwari Swasi. It has been recorded in Exhibit 2 that the partition was done in presence or in panchayat in presence of the Mukhiya and other persons, and this Exhibit 2 contains the signature of the Mukhiya, Sarpanch and other co-villagers, and also the signature of Atwar Swasi. On the face of Exhibit 2, this court is of the considered view that the same is not a memorandum of partition, nor as it does not refer to any previous partition, nor does it reveal that it is a recital of any previous partition, and the same is reduced into writing for future reference. Rather, this document revealed that by this document, the property was divided between the two wives of Atwar Swasi. It has been specifically recorded that Atwar Swasi, son of Budram Swasi, that it itself revealed that the partition was done by Atwar Swasi, son of Budram Swasi, and this document has also the signature of Atwar Swasi. In view of the aforesaid facts and circumstances, this court finds that the Exhibit 2 is itself partitioning the property, and the same, having been not registered, is not admissible in evidence. The entire case of the plaintiff was based on the partition of the property by virtue of Exhibit 2, and her case was that she was the exclusive owner of the suit property.
Suit was filed for declaration of right title interest.
And the suit was filed for declaration of right title and interest and confirmation of possession / recovery of possession. This court finds that the entire basis of claiming right title interest and possession exclusive right title interest and possession with respect to the suit property having been based on Exhibit 2, the same having not been registered, the learned First Appellate Court has rightly considered this aspect of the matter and has set aside the judgment and decree passed by the learned trial court. The substantial question of law having been answered in favor of the respondent, the second appeal is hereby dismissed.